shall be excluded from observing or listening to other witnesses, standard, and the testimony during trial, except those witnesses who are victims as defined by Idaho law and Article 1, Section 22 of the Idaho Constitution. Well, okay, but that's a problem because under Idaho law, technically, that adoption is formal and the parental rights are severed, but this, adoption didn't happen under Idaho law? Didn't. So I'm not sure what to make of it. I'm going to have Mark O'Mara in a moment tell me about that. So here's the thing. Larry and Kay have hired an attorney, and they're fighting this. And so this is not settled, okay? This is not settled, and the trial starts on Monday. So it's interesting as well, because you've probably heard the name Shannon Gray before, because the Gonzalez family in the Idaho student murders at the University of Idaho, they hired Shannon Gray to represent them in all of this. Now Shannon Gray is going to represent Larry and Kay, and together they're all going to fight this. But there's a couple of other things that I was going to tell you about. Let me ask the control room if I have time to go over the timeline, or if we should just hash out this brand new breaking news that's just dropped in the last hour. Let me get Mark O'Mara on. Mark, I had a whole big plan to go over what I said before the break and tell everybody how things all timed out in this case. But you got to hash this out with me and tell me what it means. I still don't understand what the Idaho law says about these adoptive grandparents, or these grandparents who were natural grandparents. They're natural grandparents. What do you make of it?
Well, remember, the trial has to be very fair, and that fair is defined through the defendant's eyes, right? So we start with that premise. And what it says is all witnesses are kept out. That's what we call the sequestration of witnesses, so that they don't hear the other witnesses' testimony. Great rule, makes sense. But the exception to that is victims, because victims have a vested interest in being in the courtroom. The problem with it is I think the judge made the right decision deferring to the defendant in this case, because they don't want that coming back on appeal. And if you really look at the statute, they are truly not victims because of that little glitch of the adoption. And unfortunately, I do not think they're going to be in the courtroom except when they're testifying.
So do they have a shot at fighting this? I mean, they've hired Shannon Gray, and they're going ahead with motions to say, we are natural grandparents. We have been in that child's life and Tylee's life since they were babies, or at least since JJ was a baby and Tylee was very young. Does that not count for anything, the morals of all of that?
No, it does. And from a human perspective, of course they should be there. They are the grandparents without question. The problem with it is that we have to look at it unquestionably through the prism of what is going to come back on appeal and what defendants' rights may have been violated. And remember, they could be very significant witnesses. So the infection on their testimony from being in the courtroom listening to every other witness is going to be that much more heightened. And that's why the court is most likely going to follow through with the ruling and keep them out.
And you don't think they have a shot at fighting this, or at least can they sit in the courtroom while this is being litigated, or does the order stand until the final resolution?
No, while it's being litigated, they're there. The only thing they cannot be there for is the actual trial. They can be there for motion
starts
practice.
Monday.
They just cannot be there listening to other witnesses because they are going to be witnesses as well.
And let me ask you, why? Okay, so I guess it's the advantage of Lori to not have anybody there to hear the trial testimony. But these grandparents have been there all along. They've heard everything. I don't think a lot of this is going to be a surprise to them. They were there early, and they can attest to all the communications that they had. It doesn't seem to me that it would make much of a difference. But maybe I'm just, emotional about it, and you would know better.
No, here's the way they should do it. If the state wants to try and increase the chances of getting them in the courtroom, they have to get the grandparents on the witness stand first and then get them off quickly, because then the infection argument, infecting their testimony as witnesses, is diminished greatly. And we often see that witnesses are released from that rule of sequestration once they testify. That's the only way the state can get these grandparents as back into the courtroom. And look, you and I agree, they should be there. But Vallow may not want them there just because of who she is, whatever nuance is going inside her head about this. But she's going to win at least until the two grandparents testify, and then maybe they'll be released from the role.
Well, let me tell you something. Vallow doesn't want them there because if it weren't for the diligence of Larry and Kay, she likely would have gotten away with this alleged murder, triple murder. They were the ones that wanted to hear from their grandchildren. They were the ones who diligently called, texted, begged, called police to say, she won't let us talk to our grandchildren. We're really worried. She's been acting really crazy. She just killed my brother. And I am in fear that she's going to kill the children. And what happened? So, yeah, well, too bad if Lori's mad at that. Okay, so thank you for that. Thank you for clarifying it. I think this is still something that we want to hear from the Vallows about. And